Okay, Nate, I would really appreciate it. I've been talking with Nate Holloway right now, and the fact that you have been working hard on the appeal for Markus Kaarma. Where does that stand right now?
Well, currently we're still working on the opening brief. We received transcripts probably roughly a month ago. Well, maybe about 3 weeks ago at this point, but we've already filed for our first extension. Technically, once we received the transcripts, then our brief was due in 30 days. However, we are able to seek extensions and move the court for extensions, and so at this point we've filed for one extension, so our current due date is set for early in September, so I believe right around September 5th.
All right. So now, what is involved in preparing this brief?
Well, there's a lot. First and foremost, the biggest issue was just getting the transcripts and reading through them. You really need to read through all the transcripts and be really familiar with the record. What I mean by the transcripts is that essentially everything that was said during trial, prior to trial, all hearings, the sentencing, the motion for a new trial, all of that stuff is on the record, and clerks have to go through and basically write everything that was said, who said it, and, when it was said, and it's chronological, but ultimately everything that was said or done at trial is on the record. So that has to be put in writing, and then that was sent to us, and so now I've got, over 3,000 pages of transcripts. So the first step was making it all the way through that. There's a lot of research that can be done prior to receiving the transcripts, but you really can't, write the brief until you have word for word what was said at trial and, know whether or not certain objections were preserved and how they were preserved so that you're able to put it all in writing accurately. Because ultimately that's the most critical issue, is making sure that you're factually correct, when you're informing the Supreme Court of what occurred, so that you can make your legal arguments based on that.
Now, as you're appealing, what specifically would you want the Supreme Court to do? What action do you want them to perform on your behalf?
We are asking the Supreme Court to reverse, essentially, to reverse the conviction and remand it for a new trial. Now, part of our brief, there are several issues that I'm briefing, but one of our issues is that we're asking for a venue change. Now, whether or not we can win on that issue, we don't know, but that's essentially what we'll be asking is to have a new trial and likely requesting a venue change for said new trial. But again, if it's not reversed on venue grounds, then potentially it comes back to Missoula County, where it may have been reversed on other grounds, because we have several issues, like I said, that we're taking up to the Supreme Court.
Right. How is the Kaarma family holding up under all of this? I know it just seems to go on and on. I know that there have been headlines recently regarding a civil matter that's going on between the families, the Kaarma and the Day family, which I know that you're not really dealing with, but all of this has to weigh heavily on your client's family.
Right, and you know what? I think it's hard for everybody. It's very, very difficult for them. I'm not really able to comment on the civil litigation, and frankly, I'm not involved in it. Again, throughout this process, even during trial, a lot of the focus is making sure that we are preserving these issues for appeal, and since that time, my focus now has been specifically on these issues. So, as far as anything related to the civil case and that kind of stuff, I can't really comment on it, and frankly, I'm not that familiar with any of it. Where I'm dialed in is on the appeal.
Okay.
So, again, there's no exact timetable. Right now, we're hoping to have the brief filed relatively early in the fall, and then the state will have an opportunity to respond after that. But again, trying to summarize everything that occurred and get all these issues in writing is difficult because, the trial took a couple weeks. There's a lot of information, and we have several issues that we are briefing. So there's definitely a lot of work yet to be done.
Okay. So what are you actually briefing there, Nate?
Well, There's a couple issues. I think that most people are probably familiar with the venue. Our feeling wasn't that, it was kind of framed, by some that we're saying jurors were dishonest. But that's not what we're saying. We're saying that at some point media gets so intense, and it can really affect people's perception of a case without them even knowing it. The reality is there were over 450 local news items written about this case, and we have a community of, between 110 to 115,000 people in Missoula County. So our argument is, how can you say that Markus was going to get a fair trial where essentially everyone in the community knew about the case? We had jury questionnaires that were sent out, and 90% of those that responded were familiar with the case. A significant amount of them, of those prospective jurors, have actually formed an opinion on the case. And again, those were sent out prior to Markus's alleged criminal history being published, and that was really just on the eve of trial. And that evidence is, typically not admissible. So, you have highly prejudicial evidence being published by all the local media, and that was after we had done jury questionnaires, and those were already sent out to jurors. So, again, we just feel, we felt then, and we still feel today, that venue was appropriate elsewhere, not in Missoula County, just because media concentration was so focused here in this county. And then we also argued, similar to my motion for a new trial, we were arguing that the jury should have been instructed specifically on occupied structure defense. So that's commonly referred to as the Castle Doctrine. That's how most people think of it. But it has very, very different defense standards. So essentially, if you're in your home, in order to defend your home, you just have to have a reasonable belief that you're going to be assaulted, or someone in the home is going to be assaulted. Now, assault, that means any bodily harm. Well, what was argued by the state, the prosecution argued that when Markus exited his home, that he couldn't use the occupied structure defense, so it became a defensive person issue. And there you're looking at something like a street fight, where your response has to be proportional. But the extra protections for homeowners, we feel, should have been the applicable instructions to the jury, that if Markus believed that he was going to be assaulted, that he could apply deadly force. Now, it's really critical because at trial what was argued is that he didn't believe that he was going to die or suffer a serious bodily harm. So as a result of that, he wasn't justified. But our feeling was it essentially shifted the burden and made it more difficult for us to establish our defense, because the jury was instructed on a more difficult standard for us to meet. So that's one other argument, essentially, that the state took him out of his house in order to secure the conviction.
Right.
And then we're also arguing a couple other evidentiary issues. We had some testimony that we weren't able to bring in. Specifically, we had an officer that was leaving the scene of the investigation, and he indicated that it was a scary situation, and that he's essentially not surprised that when you have a family at home and they have an infant, that someone who burglarized the home, that there was a shooting. And we weren't able to bring that in and have the jury see that evidence because it was excluded. So again, there are certain evidentiary issues that we're addressing, the venue, the jury instructions, and then we had some issues with some of the jurors, that specifically one juror that we attempted to remove for cause. And by that I mean we tried to get the juror removed due to ties to law enforcement, and we weren't able to, so we had to use our own challenges to remove that juror, and that's another issue that we're appealing. So there's at this point between 4 to 7 issues that we're really dialed in on, but that's kind of a brief summary of where the appeals